Hello, I'm Bill Peterson, Minnesota probate attorney. One of the questions that frequently comes up is when we have more than one executor or personal representative on an estate, how can decisions be made? In some instances, there can be these co-executors, or another name for this under Minnesota probate law is co-personal representatives. It's not uncommon. However, it can also pose a serious problem. What happens when the co-executors disagree on how to handle the estate? Let's look at an example with two cousins, Betty and Kim. Betty lives in Chanhassan, not too far from her Uncle Jerry. Jerry was a brother to Betty's dad, and she remained close to her uncle through the years. Over the past winter, Uncle Jerry struggled with heart disease and eventually passed away in February. Betty was saddened by the event, but took comfort in his passing as Uncle Jerry was in great pain. Prior to his passing, Uncle Jerry had told Betty that she was going to be a co-executor for his estate, along with his only daughter, Kim. When they were younger, Betty was like an older sister to her cousin, Kim. As they entered adulthood, however, Kim had moved to Nevada and they had grown apart. Now, with Uncle Jerry's passing, Betty and Kim are reunited under perhaps less than perfect circumstances. Jerry had set aside most of his assets, which included a pickup truck and a house and bank accounts, to Kim, with a single 10-ounce gold bar going to Betty. In addition, there are about $10,000 worth of bills that have accumulated, which Betty has collected. Betty has now discovered that Kim has placed the pickup truck and house up for sale. With her name also listed as co-executor, Betty is concerned that Kim is not addressing the outstanding bills that the estate owes. Well, what can she do? According to Minnesota law, when there are co-executors or co-personal representatives on an estate, it takes both signatures in order to sell or to transfer ownership of the asset. Thus, Betty has the ability to say no on any sale if she doesn't think that that particular sale is a good idea for the estate or for the return that it might have. The bank account that receives the proceeds from the sale of assets should be put into an estate account at a bank that both executors have access to. Now, Betty is wise to be cautious about what she does as a co-executor, because really, Betty is serving as an officer of the probate court, and she has legal obligations to the creditors, to the heirs, as well as to the court. A personal representative can be personally liable if he or she violates any of these duties to others. Betty is well advised to be careful. If she encounters problems, she should consult with a probate attorney to be sure she's doing everything correctly. Incidentally, the legal fees that Betty incurs to get this advice is normally payable from the assets of the estate. I'm Bill Peterson, Minnesota probate attorney. If you are having these kinds of issues in your family or with your probate, I can help. Please give me a call for a free, no-obligation consultation at 952-921-5818. And I hope you have a fine day.